Welcome back to RR Corporates. Now we are discussing a special notice under Companies Act 2013. It is governed by Section 115 of Companies Act 2013 and Rule 23 of the Companies Management and Administration Rules 2014. So this is effective from 1st April 2014, being the notified date of the Companies Act 2013. So now the question, who is eligible to give a special notice to the company? Special notice can be given by members, shareholders, and the date of the notice satisfy any one of the following condition. Condition number 1 is hold not less than 1% of total voting power, 1% of total voting power, or hold shares on which an aggregate sum of not less than 5 lakh has been paid up. So this eligibility requirement is prescribed under Rule 23 Sub Rule 1. Can a special notice be given by a single member? Answer is yes. Special notice may be signed individually or collectively, provided the eligibility threshold under Section 115 read with Rule 23 is satisfied. Clear? So what is the time limit for members, that is shareholders, to send a special notice to the company? The answer is special notice must be sent to the company not earlier than 3 months and at least 14 clear days before the date of the meeting. So the day giving notice and the day of the meeting as excluded while calculating this period. Another question, what is the company's obligation after receiving a special notice? So upon receipt of the valid special notice, the company must inform its members about the proposed resolution, give notice at least 7 clear days before the meeting. So follow the same mode of communication as used for general meeting notices. Generally how it will proceed for general meeting notices. So what if? So the question is, what if it is not practicable for the company to give notice in usual manner, if not able to give? So if it is not practicable to circulate the notice in the normal manner, so the company shall publish the notice in an English newspaper and in a vernacular newspaper, local language, both English and local language publication. Both newspapers must wide circulation in a state of registered office. So the notice must also be posted on the company website, if company has website. So what is the minimum publication timelines for newspaper notice? The answer is the newspaper notice must be published at least 7 clear days before meeting. So the day of publication and the day of the meeting. So that way you can calculate 7 clear days before the meeting, excluding the day of publication and excluding the day of the meeting. That is what wherever we are mentioning clear days. So which resolutions typically require special notice? Special notice is commonly required for resolutions such as removal of director before expiry of the term. We have already discussed Section 169 in another video, removal of director, and appointment of an auditor other than retiring auditor, and removal of an auditor before expiry of term. So we have already separate video on this removal of auditor before expiry of the term, and any other matter where the act or articles specifically require special notice. Hope you are clear. Is special notice the same as a special resolution? The answer is no. Special notice related, this is a different, special resolution is different. Special notice relates to advance notice by members. Special resolution relates to voting threshold 75%. Resolution may require special notice but still be an ordinary resolution. Resolution may require special notice but still be an ordinary resolution. So both are different. Special resolution is different, special notice is different. So there is no confusion. So what is the consequences? Non-compliance with the special notice requirements. If special notice is not validly given, then the resolution becomes procedurally defective, so it may be challenged as a invalid. So regulatory and governance risks may arise, especially in the listed and closely held companies. So we have to be take care. So is special notice mandatory in all the companies? See, special notice is mandatory only where specifically required under the Companies Act 2013 or Articles of Association. It is not a universal requirement for all the resolutions. So what is the practical compliance takeaway for these companies? So companies should verify first member eligibility, because just now I explained the eligibility, and then timelines, follow strictly timelines, and ensure proper circulation or publication. Maintain documentary proof for secretarial records and audits. This is what about the special notice under Companies Act 2013. Hope you are clear. Thank you. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe, hit the bell icon so that you will not miss any of my latest videos. Bye.